It's approximately 2 hours. I have a number of slides that we'll go through, and we split this, hey Greg, we split this over two nights. So this is kind of part one, and then next week is part two if you haven't signed up for that. We used to do it split into, tonight was a basics course, and then we would do an advanced course. We've moved away from that. After doing this for, I don't see Georgie, we've done it for, goodness, 12 years now, something like that. Long time. We have evolved, and I've actually got new slides, no new jokes, unfortunately. But we're going to do part one tonight, so I'll cover a little bit of introductory stuff, but we're going to cover substantive issues tonight and then substantive issues next week. Standard disclaimer, the way this works, and this is one of my favorite things to do because it's a conversation primarily. I have things that I want to make sure you leave here with, but we leave a lot of room for questions. And used to be we would say, well, I'll blow through all my slides and then we'll handle questions. I've evolved with that a little bit too. If you have a question, go ahead and ask it. And it may be that I'm going to cover that and I'll say, wait, remind me when we get to that slide and we'll cover it later. But this is a very interactive kind of presentation. Because I'm a lawyer, because I represent clients in court and in transactional matters, and there's a certain formality that happens to create an attorney-client relationship and the confidentiality that comes with attorney-client privilege. What we're doing here tonight is not establishing an attorney-client relationship, either with you personally or with your association. All right? I will try to answer your questions as best I can. But more than likely, and we'll talk about enforcement issues next week, but you want to know how to get rid of that god-awful yard art that the neighbor put in. We can talk somewhat about that, but I can't get into the specifics of any particular case. But we'll do our best. I'll try not to dodge your questions. So let's start off with just making sure that we're all on the same page and having a discussion on what are the basic documents, or what's the basic framework for creating these associations. Okay, so we're going to talk about the documents that create community associations. All right, and initially it starts with the filing of the plat for most additions. If you're a homeowners association, if you're a condominium association, you may or may not have a plat. And then it'll go from filing of the plat or having the piece of ground where the development is made to filing covenants. Now, you may look at your neighborhood covenants and it may say owner's certificate. It may say deed of dedication. Is there anybody from Tulsa County or surrounding area tonight? Okay, we won't talk about their form of doing it, which is a little different than how we do it on the western side of the state. Most of the time what you'll see is a declaration of covenants, conditions, and restrictions. It really doesn't matter what it's called. What we're talking about is the document that's filed at the county clerk's office where the development sits. So for land, if this building was a condominium, the covenants would be filed in Oklahoma County because that's the county where we are. Those covenants are going to have use restrictions and structural restrictions. Okay, it's going to talk about what you can and can't do with your property. It's going to mention a homeowners association or community association if one is created. Oftentimes a question is, do we have a community association? And the first place you go to look is a plat, if you have one of those, and see if it mentions a community association. Then the second one would be the covenants. If you look at your plat, if you look at the covenants, and it doesn't say anything about a community association, more than likely the answer is no, you don't have a mandatory association. You can have a voluntary one, like a neighborhood watch or something like that. And there is a process under Oklahoma law to create a mandatory association if one doesn't exist. Then, if you do have an association, oftentimes, hopefully every time, it will be an incorporated association, and that's created by filing articles of incorporation with the Oklahoma Secretary of State. If you find that articles of incorporation have been filed with the county clerk along with the covenants, that's fine. It just doesn't create a corporate entity. You have to create the corporate entity through a filing with the Oklahoma Secretary of State. If the articles are filed in the county clerk and not the Oklahoma Secretary of State, what you have is an unincorporated association, and that's bad. So takeaway number one tonight, if you're writing anything down or remember anything, check to make sure that the association, either that you're a member of or a board member of, is incorporated. It's very easy to do, doesn't cost a whole lot, and the benefits are tremendous. And we can talk about that if there's more questions. So bylaws are not covenants. This is primarily the reason why I have this slide, because invariably someone emails me or calls me or we're having a conversation and says, I want to know how we can amend our bylaws. Well, that question triggers a response that sends me down the road in answering how you amend bylaws. And invariably, if they mean covenants and they tell me bylaws, we are now going in separate directions and they're going to get confusing information. Bylaws are not covenants. What's even worse is some developers decided to file bylaws that are embedded or incorporated into their covenants. And it even says bylaws inside the covenants, which creates an interesting question of, okay, how do you amend bylaws that are really tucked into covenants? Because the amendment process between covenants and bylaws are very, very different. Different standards, different sections of law. So bylaws deal with the business of the business. They're going to answer questions like, what is the principal place of business for your association? How often does the association meet? How many members are on the board if the articles of incorporation don't answer that question? Can we use proxies? What records access do I have? The business questions for the corporate entity, okay? It doesn't tell me how I should pay dues or how much, although again, confusingly, sometimes that information is tucked into bylaws. It doesn't tell me whether I have to get permission to put a sunroom on my house from an architectural committee, although, again, confusingly, sometimes there's architectural committee language in our bylaws. Those things are covenants and should appropriately be in our covenants. And then we have corporate resolutions, rules, and regulations, which are more corporate documents. So this is what a plat looks like if you've never seen one. What a plat does is essentially takes the survey for dirt, real estate. If you've ever looked at a survey, one that's not tied to a plat, it's going to have a lot of letters and numbers and degrees and so many feet, thence, north, and have that kind of language. That's called a meets and bounds description. What a plat does is allows us to refer to places on the earth as lot and block. It converts what's somewhat of a difficult way to figure out where is this land to, okay, I've got lot, block, and the name of an addition. The filing of the plat with the county clerk's office is what makes that happen. But it's not just a means of getting us a lot and block legal description. It gives us much more information. It tells us what common areas are platted within the neighborhood. So for this neighborhood, which is in Edmond, it has a very large common area in the middle, and you probably can't read it, but that says common area. And so this plat answers the question, what common areas are there? And then we would go to the covenants for further information on who maintains it, to what level are they to be maintained, what rights would I have as a lot owner. This happens to be a wet area, it's a pond, and can I fish there? Can I water ski there? The covenants will answer those questions. Typically the plat will not. One other thing that the plat can answer for us too, and I know you can't read this, but on most plats there's a section, and that blob right there says notes. A lot of times plats will have a notes section, and that notes section is very important in answering some crucial questions. The one we asked a minute ago, do we have a community association? If the plat's filed in Oklahoma County, if it's filed within the city of Edmond, Oklahoma City, Mustang, Norman, most municipalities will require, if you're going to file a plat like this that contains common area, the plat must also provide that there is a community association created. And it'll usually have language that says, common areas shall be maintained by a property owners association comprised of the lot owners. That's creation language. It's not very good organizing language, but it is creation language. Okay? Oftentimes the plat notes also will say something about setbacks. It might have tree installation requirements, and those are structural and use restrictions. Okay? Those plat restrictions are as valid as a separately filed set of covenants, okay? Called plat restrictions.
Question about frontage road on a major street, a subdivision backs up to a street, and so an easement, we mow it. I don't know if we have to or what calls for us to mow it, but we do. Is that a common area?
Maybe. It depends. And so here's a couple of ways that we handle that. So he's talking about this street right here, which I believe is Santa Fe. Yeah. So you've got Santa Fe, yeah. That is a section line road. It's a statutory road. And so you've got 33 feet on either side, and then typically a developer will do a setback, so you've got a little bit of a green area there. That's the area that you're talking about. There's a couple ways of handling that. This plat handles it where it's defined as common area. You see the solid line here? So that is platted common area. It goes all the way to the section line easement. That's a really good way. That's my favorite way of doing it, so that once we go to the covenants, the covenant should have a definition section, and it will define common areas. And it'll say something like everything that's platted as or depicted as common area on the plat. So there we have it. That is a bright line. The association mows this, maintains it because they control and maintain the common area. I would say that's the exception, not the rule. A lot of times what you'll see is you'll have the black line here. You'll have common area that stops here or so. You'll have a fence, and you've got this grassy no man's land there. Oftentimes, let's pretend that the section line is right here. Oftentimes you'll have a lot, and their lot line goes all the way to the section line, but the fence is right here, and we have that grassy area outside. Technically, that's owned by the owner. What we'll do is, in addition to having a common area, and I apologize for my writing, my R's look like V's and my A's look weird. Often what we'll do is we'll have a definition of common area, but we'll also have a definition of area of common responsibility. And what this definition will say is the association may maintain areas depicted on the plat not owned by the association, but that it's generally understood or agreed to benefit the neighborhood. Okay? It's kind of a vague, we know it when we see it, we know it when we want to maintain it. Primarily what we're talking about are these areas here. It's property that the association isn't going to own, doesn't want to own, but most people will agree it benefits everyone in the neighborhood for that to look nice and neat. If you need a really good visual of what I'm talking about, drive along Memorial Road across the street from Oklahoma Christian. There's as you move east from that light there right in front of Oklahoma Christian, there's a neighborhood, University Park Estates. It has a mandatory association. It's a gated community. It's a little bit different type of development than as you move to the west. So it's somewhat apples and oranges, but the point is it's very well maintained. Nice, beautiful entrance. As you move west, there's a neighborhood that does not have a mandatory association. And what you see is each individual owner maintaining that right-of-way. And so you have the gentleman that has the vegetable garden growing in the right-of-way. I'm a big vegetable garden fan, just not in rights of way on section line roads. You have guys like me who think grass is for cows and doesn't mow, and their grass is like this until the city tells them mow it. And then you have other folks that manicure it. So you have this non-uniform presentation as you drive into the neighborhood. It really benefits this person to have an association uniformly maintain that, because the curb appeal doesn't start when they pull into this cul-de-sac. The curb appeal starts when they're on the section line road and decide, that looks like a nice neighborhood, I'm going to move in there. That's why we do areas of common responsibility, and oftentimes, even if this isn't a settled question, even if you don't have the definition of area of common responsibility, you'll have associations just take it upon themselves to mow or maintain that grass area. Okay? So let's talk about the development process. I think sometimes this will help put together the framework, and then we can move on to some of the substantive questions. So at some point, the parcel that's going to be developed is zoned, rezoned. Some of y'all may have been involved in receiving a zoning notice. You have some apartments going up next door, and city council meetings, you go protest. That's part of the zoning process. Filing the plat usually is at the end, where zoning has already been obtained, has to have already been obtained, and they're ready to start moving dirt, cutting streets. So we file the plat. Sometimes the association is incorporated at this point, even before the covenants are filed. Doesn't have to be, but one of the things that we do with drafting, one of the things that you can do as board members with procedure policies is take arguments away from people. The less ridiculous conversations I can have, the better. And there are some conversations that are good faith disputes, and they are well worth having because I learn things from those. And then there's others that are people that just want to argue in bad faith, that are not aware of the fact that they bought into a neighborhood with a set of covenants. It's just a lack of awareness issue. One of those that comes up occasionally is, well, the covenants were filed and the association was incorporated later, therefore the association is not valid. No, that's not how it works. And so sometimes, just as taking away that argument, we'll file the Articles of Incorporation first. It really doesn't make any difference from a legal standpoint. You've got the plat, and then the covenants filed with the county clerk. Now, it is a real big problem if we jumble up filing plat, selling lots to individuals, and then filing the covenants. If you have that situation, you probably have individuals who are not subject to the covenants. And I'm talking about a timeline here. So we have plat filed. We have ANSI builder or developer, and we have lot sale, lot sale, lot sale. And then CCR is just shorthand for covenants, conditions, and restrictions. So the covenants get filed here. Then we have more lots sold. We have 4 lots that arguably are not subject to the covenants. Okay, that's a problem. It's definitely a problem in a neighborhood where we have a mandatory association, meaning the idea is that all of the lot owners will be members, mandatory members of the association. It's a problem if we have a gate on our private streets. So then the question is, all right, they're not members, so they don't get access to their house, right? No, does not work that way. Very, very coercive, but doesn't work that way. It's a problem, and we have to fix it. And there's a couple of ways of fixing it.
Or can, when they sell the house, the new owner go under the covenant?
Nope, it doesn't work that way. It can, and that's one of the ways we fix it, is we have this person basically execute a lot declaration. It's their own mini CCRs. And what it says is, I'm not subject to the covenants. I'm making a voluntary subjection of myself and my lot for as long as I own it to the covenants that are recorded. That makes it good. But and most people that buy into a neighborhood, they buy into it because, not necessarily because it has a homeowner association, because I think if you twisted our arms, most of us would say, we don't much care for associations. But that's like saying, I don't much care for the government. We say that, but we don't really mean it. We may mean I want a different version of the government, I want a different version of the association, I want them to not tell me what I can and can't do, but I definitely want them to tell my neighbor what they can and can't do. That's usually what we mean when we're saying I don't much like homeowners associations. So what this does is gets them back into the fold, but sometimes, there's always one says, I get to enjoy this special status of not having to pay my dues and enjoying all the benefits. And that may be true, depending on the facts and circumstances. It's difficult to take that position in a private road community. Okay, we have pretty good case law in Oklahoma that says if you live on a private road, you have to pay your fair share. That's a matter of case law, whether the covenants specify that or not. If it's a public road, it's a little bit tougher sell. Okay? Yes, ma'am.
Are there private roads in neighborhoods as well, or are you just talking about someone's land where there's... Because my neighborhood, it's all public roads. I'm just trying to understand what makes something a public or a private.
There are. What makes them public or private is if there is a dedication or a reservation of that road on the plat. And the plat answers that question as well. If you see a gate on a neighborhood, it's a private road community. Do not have to have a gate on a private road community. There's any number of neighborhoods that are private roads that don't have a gate on them. Okay. So at some point, typically after the developer has sold all of their lots or some time within that period, and I'll go ahead and mention, so if you get on the internet and you do research, and you're wanting to answer the question, when does my developer have to hand over the association? My guess is you're going to get the answer wrong, because what you're going to do is pull up a statute from another state, or you're going to pull up a blog or someone who says, well, as soon as it hits 75%, that's the magic number, right? But it's not in Oklahoma. It is in Colorado because it's a Common Interest Ownership Act state. It's similar in other states, but that's not how it works in Oklahoma. It works in Oklahoma based on what the covenants say. And unfortunately, in Oklahoma, we have a development culture that doesn't often answer that question in our covenants. And so it may be you scour everything. If you scour Oklahoma law, you're going to find no language on developer transition. If you look at the covenants, hopefully they've provided for it. And what I'm talking about with developer transition is, when do the resident or the occupant owners get control? And it's not just control of the association, it's also control of the Architectural Review Committee or Design Review Board, however it's designated in your covenants. It's going to happen at some point. It may happen when the developer sells all of their lots and no longer owns real estate. However, I draft my developer covenants that's not the trigger. The trigger is basically when the developer says they're done. Because there may be, say this is Plat 1, and developer has one lot there, sells that lot, but now they've decided they want to develop this 80 over here into phase 2. Well, the covenant should provide for that. That's a very common thing to happen in development. And the covenants, one of the things that the covenants do is provide people notice. And we can argue that, well, maybe they don't give enough notice. And most developers are not going to spell out in their covenants, hey folks, y'all are in phase 1, I anticipate 6 more phases, because they may not know that. What they're going to do is reserve the right to annex or add additional lands within the covenants. That's your notice, okay? So transition may not happen for many years. It may not happen for many years because we have phases 3 and 4 coming down the pike. It may be because something happens like what happened in 2007 and the real estate market just crumbles. And developers are not turning any more dirt because they're sitting on a ton of inventory they know they're not going to sell for a while. So it may take a long time, but at some point, it's built into the life of most developments that developer is gone and individual owners take over. Hopefully, the developer or sometimes builder has done a good job of preparing the neighbors for taking over. Okay? And what I mean by doing a good job of preparing for takeover is sometimes developers will hold annual meetings, they will give development progress reports, they will have individual owners, occupant owners serve on the board. It's not just developer, her husband, and their secretary. They have some kind of involvement with the resident owners. And you'll see this transition process. And unfortunately, sometimes the process is letter in the mail, I'm done, y'all take it over. And that's usually scramble mode where, Georgie gets a call or my office gets a call, what do we do now? That's not a really good way to hand it over. Having some kind of smooth transition, and if you happen to be in that situation, if you're in a neighborhood right now where you've had it dumped on you, or hopefully you can see the transition coming, you don't necessarily have to wait for the developer to initiate that process. Some developers are just not on their radar. They're too busy selling dirt and looking at the next development to think about that. And so forming a transition committee, suggesting to them, hey, why don't you involve us? We'll serve as a committee, we'll do the newsletter, the welcome to the neighborhood stuff, and start the wheels rolling on when the developer's ready to hand over the association, you guys are ready to take it over, okay? And then the continued operation of the association. And that's probably where most of you are and where we're going to spend the most of our discussion. If there's more transition questions, holler at me and we'll cover them either tonight or next week. So the law on homeowners associations is not what my brother-in-law tells you it is. It's not what you read on the internet necessarily. It's definitely not what happened in the neighborhood across the street where they fined someone and they got all their money back when they took them to court. The law is either a statute that the Oklahoma legislature has adopted or at the federal level, not so much applicable with most association questions, but there are some. It's the statutes and then case law. And it's not just case law, because we can have a case like the neighborhood across the street where we know they took someone to court, they won, they got all their money back, and therefore that means your association can do the same. No, like we talked about, different cases have different facts, different nuances, different parties, different economic factors. That's often the biggest issue with litigation. But it's case law that our Oklahoma Supreme Court has published or allowed for publication from the Court of Civil Appeals. If you're not familiar with oscn.net, you really should be. Not just for getting access to the law, but if you do have court cases, you can follow the docket. You can download all of the pleadings, which are the documents that are filed in a court case. You can pull all of that off OSCN. If you want to read the child support guidelines from your neighbor that's getting a divorce, that's where you find it. Okay, it's often more entertaining than Facebook. The law in Oklahoma on community associations, there's not much, and it's old. It has not been updated. We tried to run a bill a couple years ago to fix a stormwater detention issue in Oklahoma City. We had Oklahoma County, Oklahoma City, one of the largest, oldest developers in Oklahoma City or Oklahoma County area, all supporting this bill that we drafted, and it didn't get out of judiciary. And the response from the judiciary chairman at that time was, yeah, we don't like homeowners associations. We're not going to let bills out of committee. Okay, that at least you're plainly spoken about it. So don't look for any help from the legislature anytime soon, and you haven't gotten any help in years past. We have a Corporations Act. It does not specifically mention community associations. There are, however, and this is Title 18 is the Corporations Code. That 865, 866, and 867, I would encourage you to go read that and look at it. We'll talk about it at the end of part 2 next week, but there's some really good board member immunities that we were able many years ago to tuck into the law there. This is right down in take home number 2. I'll go ahead and tell it to you. So there's something called a Form 1120H. By the way, I think Neighborhood Alliance puts all of the slides that you're going to see online. I think they do that. By the way, I'm not a tax lawyer. I'm not giving you any tax advice.
Matthew, we email to each one that's here.
Okay, good. Excellent. So Form 1120H, and this is a form that's tied to Internal Revenue Code 528. Do we have any, is there anyone in here on a commercial community association? You hear from a commercial or an office community association? Yeah, that would be unusual, but okay. So this is just for residential associations, condominiums and homeowners associations. You can go read section 528 in the Internal Revenue Code. You can download Form 1120H. It's got 1, maybe 1.5 pages of instructions. It's very straightforward. This is the way that your community association, 1, elects to be taxed as a community association, and more than likely your association will not pay tax. But again, you need to get tax advice on that, and you can read the instructions and probably figure it out yourself. But what we did was, under Section 865, for an association that files this or makes this election every year, filing the 1120H, that's what gives that association board members access to the immunities that are provided within that section of law. Very, very good protection. Okay, so make sure you do that. Title 60 is our real property section in Oklahoma. Section 501 is our Condo Act. It's about 30 sections of law. It was adopted in the late 60s. It hasn't been updated since. It's a first generation condo act, and so therefore it doesn't answer questions like, does your condo have to have a reserve fund? Which is one of the most fundamental things, and this gets into your area. There are a lot of associations because the law doesn't provide it, because hey, why should I make a $5,000 special assessment now when we can just defer that maintenance? There are a lot of condominium associations and some homeowner associations that have significant amounts of deferred maintenance, and those kinds of special assessment amounts are not going to be adopted to get paid. You're going to have to borrow the money to do it, more than likely. So if you're in a condominium, one of the questions you need to leave here asking is, how much do we have in deferred maintenance? Okay. Yes, ma'am.
Does a regular HOA have to have funds in deferred maintenance?
You do not have to have a reserve fund, whether you're a condominium or a regular community association like a homeowner association. But anytime your association, or any business for that matter, owns something that wears out, and so for condominiums, it's usually the building, the roof, the facilities, the plant. For community associations, the number 1 is private roads, if you're a private road community, and number 2 is detention ponds. The purpose of detention ponds is to silt up. It's to catch silt, and over a period of time, that pond is going to silt up. And once the silt hits the surface, it's time to dredge it. And has anyone gotten a cost estimate on dredging a pond? It'll knock your socks off.
And then what do you do with the spoils too?
The spoils of,
With the stuff you dredge out?
if you're smart, you sell it and offset some of your costs.
Whitehall is built on Silver Lake spoils.
What's that?
Whitehall is built on Silver Lake's spoils.
So the dredging expense is up there. And this is really, I'll try not to harp on it, but this is really a big area that I cannot believe our legislature does not act on. I'm typically a smaller government kind of guy, but this is an area where government really needs to take the lead because we don't have a culture of management here. It's primarily self-managed. Your associations are self-managed, and unless somebody thinks to ask the question, it just is off the radar. And there are associations in Oklahoma City, not a whole lot of them thankfully, but the ones built in the 60s, 70s, with so much deferred maintenance, they're already scraped, they just don't know it yet. And the newer associations are in a better position because they're newer, they don't have so much deferred maintenance, but they should have a reserve fund. So for example too, it's not just replacement of facilities, it's also insurance deductibles. So I haven't looked at this recently, y'all probably know this better than me, but for a while there, condominium insurance deductibles were getting in the tens of thousands. And so if you don't have that, if you work on a month-to-month basis, so you have an event that you need access to the insurance proceeds, but you have to pay your deductible. Well, wouldn't it be nice to have that money in reserve so that you can have access to the insurance proceeds like that? What are the chances if you need access, you need to raise $50,000, your members are going to adopt a special assessment? Those votes typically go down in flames. And so now the board is trying, they're doing everything they can to get these things fixed or raise the money for the insurance deductible, but the members have said, no, I can't afford that. So you just continue on as you are. Not a really great way to do business.
Question.
Yes, sir.
There's directors and officers liability insurance, and then you talked about the immunities offered by the tenants. Can you just comment on, you get directors and officers liability insurance even though we've got this immunities?
The short answer is absolutely. We cover insurance in part 2, but the quick answer to that is for directors and officers, you want insurance not necessarily to cover a judgment that's going to get hit or that is going to hit against the directors, but to cover the attorney's fees in the interim. If you haven't been involved in litigation, we're incredibly expensive, and we send bills on a monthly basis. And there might be an opportunity to recover attorney's fees at the end of the show, but maybe not. And so having an insurance company at least covering the cost of defense, that's the big benefit in my mind of D&O, directors and officers insurance. So I'll do my best to convince you that you don't ever want to do business as an unincorporated association, whether that's you're a roofer, you're a lawyer, or a community association member, because anytime you have two people, and this is under Oklahoma law, two people coming together for a common purpose, definitely collecting money, putting it into a common bank account, maintaining property that they don't own, we are creating significant personal liability for those members. And we shield from personal liability with insurance and corporate structure, okay? So again, I would encourage you to go look. You can go to the Oklahoma Secretary of State's office, or website, excuse me. I guess you could go to their office if you wanted to. It's easier to just go online. They have a business entity search, And kind of begs the question, well, if I don't know if we're incorporated, what do I search for? Plug in the name of your neighborhood. If you have a copy of your covenants and there is a name of an association listed in your covenants, then do a search of that name or some part of the name, and hopefully it's incorporated. If it's not, it's a $25 filing fee. It's pretty straightforward, one-page application, well, not an application, but form that you can file online and get your association incorporated. Yes, ma'am.
Our association's incorporation status lapsed at one point in time. And when I took over the duties, I discovered that.
Is it an LLC? Was it filed as an LLC?
I don't remember. I got it reinstated.
Mm-hmm.
But during that lapsed time, we had some amendments made to our covenants.
Uh-huh.
Or one of those documents you talked about.
Right.
Those, and it looks like our incorporation was made retro to when it lapsed. So would any official stuff that we did in that meantime, in that interim time, be valid?
Yeah, that's a lawyer's playground that you just described. And I'm not going to be able to give you a "this is the way it is" answer. It really does depend on how your covenants are written. It depends on what entity. Now, there's a couple of things that you did say that I want to cover. So when you file a not-for-profit in Oklahoma, it does not lapse. It never lapses. When you file a not-for-profit in Oklahoma with the $25 filing fee and you use the not-for-profit form, once you create it, you have to kill it. There is no function where it just lapses. What does lapse are for-profits, because you don't pay your franchise tax, or LLCs, and because you don't pay your annual $25 fee. There are some associations that are created as for-profit, and those are usually sportsman-like clubs, fishing communities. You might have an airline community, although most airline communities that I come across do create non-profit or not-for-profits. Sometimes you'll see, for whatever reason, the association formed as an LLC. I have someone argue with me on, about once a decade that no, that's the way to go, and I'll revisit it, and I've got my little spreadsheet, my pro and con spreadsheet. I have not found a good reason to form a community association, a residential community association, as an LLC. There's no benefit in doing that. So typically what we're dealing with are not-for-profit associations. They don't expire, don't have to worry about the lapses, because when they do lapse, when an entity does lapse, it creates a lot of questions. Are the board members, are the individual members liable for that period? Are covenant amendments invalid during that period? Again, we can avoid all of those sticky situations and questions and discussions just by creating not-for-profit, and it doesn't lapse. Okay. I'll jump to the bottom here because we're at our 1 hour. The short of it is, don't ever participate in business, whether it's for-profit or not-for-profit, in an unincorporated association. Okay? If you're going to open a business with your spouse, form an entity, because you've got an unincorporated association and your personal assets are at risk. Okay? Let's talk a little bit about meetings. I hate going to these things. I sat through 3/4 of a day of a CLE today, so this is fresh on my mind. I can't stand it when I'm in the audience and the speaker thinks I can't read, and all they do is just read the slide. I'm not going to read the slide to you. I'm going to tell you what I think is important, and it may or may not be exactly on the slide. I got feedback one time that someone wore me out because I didn't cover each bullet. I think they were an engineer or something, Craig. Craig's an engineer. So what I want you to know about meetings is, number one, have them. Whether it's annual meeting or board meetings, that's how the business gets done. And there are default provisions, yeah, so if we don't have an annual election, Oklahoma law provides, if you're incorporated, that the current board just continues. Was that an earthquake or a helicopter or something? The board that's in place will continue until the next election or until somebody files a lawsuit to have a judge oversee an election. But have an election. I mean, one of the conversations that we can very easily avoid, and that conversation is the board's stealing our money, the board's hiding something from us, there's this conspiracy, there's this cabal of owners that's running everything, which is true. It's called a board of directors. That's why they're elected to run things. But, you know, there's this tinge of suspicion. Well, just, you know, get rid of that by putting all of the books and records that you can, subject to privacy laws and good taste, online available to members, and have meetings. At those meetings, have a podium or some mechanism for having comments. If you go to, say, City of Edmond or City of Oklahoma City planning meetings or council meetings, you'll see how a probably more formal than what you're needing, but how a good meeting is often run. Sometimes they devolve and go nuts, but not often. And the reason is because they have an agenda, a written agenda. They follow it. They have an order for comments. They allow the citizens to say their piece, and when things get redundant or repetitive, they'll move things along. It's perfectly fine for your board to do that, okay? I'll go ahead and mention, I think this is on another slide, the Oklahoma Open Meeting Act does not apply to your community association. And it's up to you, but if you make your meetings or your association subject to the Open Meeting and Open Records Act, what you've just done is subjected your board members to civil and criminal penalties for violations of the Open Meeting Act. You don't want to do it. There's no reason for our community associations to be subject to that, okay?
What is the Open Meeting Act?
Open Meeting Act is a statute that governs how government is to communicate with the public, how it's to give us notice of meetings, how they're to conduct the meetings, when they can go into executive session and when they can't. It's very, very strict, and there are significant penalties for violating the Open Meeting Act. The boards for our community associations don't, I mean, you're non-compensated, you're not thanked. The last thing you want to tack onto that is civil and criminal penalties, okay? So having some oh, it is on this one. Having some semblance of openness is a good idea. I get this question quite often. Do we have to let members come to our board meetings? Well, no, you don't have to, but I mean, I don't have to tell my wife I love her every morning, but there are consequences if I don't. So, you know, you don't have to do that, but it's usually a good idea, right? A couple of other tips. And I used to be able to say this worked every time. I had a guy at a meeting that apparently it doesn't matter what setting you're in, it's just coming out, no filter. Used to be, people would be on their best behavior if they're sitting in a church building or an elementary school. If you think you're going to have a hostile meeting, schedule it at a church building or an elementary school cafeteria. And the reason is, one, they're usually free. Two, people tend to be on better behavior, okay? There's nothing wrong with having it at the pool. I would strongly suggest that unless you're doing some kind of Christmas party after the meeting, get your business done first, and then serving alcohol, don't serve alcohol at an association meeting. That seems to be kind of a no-brainer, but that comes up occasionally. One of the things, and this really hits, I think, guys more than it does lady board members, and that's think in terms of how to encourage people to attend the meeting, and that's childcare. There was a time in my life that I wouldn't be caught dead in public with some of my girls, and they're very well behaved, but I just don't want, to break out in that sweat when they start freaking out and, disrupting. You can communicate as a board that children are very welcome, that childcare will be provided, and it's the difference between being in those assemblies where people give you dirty looks when, kids are being children, and those settings where kids start screaming and somebody makes a comment to break the ice about, glad to hear some children have lungs or something along those lines. The whole point is whatever it looks like for your neighborhood, try to make those meetings as accommodating as possible, and you'll hopefully see better than a 5 or a 10 or 15% participation, because I don't know about your association, but the ones that I typically represent, we're looking at 20% of the neighborhood showing up for an annual meeting, and we're celebrating. There's just a whole lot of apathy that goes on.
Matt,
Yes, ma'am.
how many is a quorum?
We'll just go ahead and skip
How many
it.
is in the quorum?
A quorum, it depends.
Oh, it's in the,
So a quorum is the minimum number of people that you have to have in person or by proxy in order to conduct business. It should be in the bylaws. Now this is tricky because it's real common in your covenants, in some forms of covenants, in that block of language that talks about if we're going to raise dues, if we're going to raise assessments. For some reason, it became fashionable, I guess, or this was the form that became popular, that just when we're raising dues, it has a completely separate set of meeting requirements, meaning how much notice do you have to give, how many people we have to have for a quorum, and then what percentage to adopt it. It's really weird because it's like this outlier from all the rest of the corporate business. But you need to be aware of that. If you have different quorum provisions for different sets of circumstances for your corporation, as a board you need to know that, because we want to avoid the conversation, all right, we went through our normal bylaw provisions for holding a meeting, giving notice, having a quorum, conducting a vote, and we thought that we got this done, and now that person sends an email and says, well, hey, what about this? And we have to go back and redo it. Okay?
Are the dues then a function of the membership, or are they a function of the board as far as assessing the dues? Who says what the dues are?
The covenant should answer that question. The preferred way of doing that is the covenants really need to specify that the board will establish a budget. I'll use my covenants as an example. It's no secret attorneys work off forms, right? So my basic form says the board adopts a budget. They send that out, I think it's November, December, because we do typically a calendar year. They send it out to the members, and unless a certain percentage of the members call a special meeting and reject that budget, then that budget goes into place. So what that does is that puts the burden on the members to reject the budget. Because if we all know what would happen if it was the opposite. If we had to rely on the members to approve the budget, we'd never get a budget adopted. But if enough people are agitated or interested enough to reject it, they can. Otherwise, the budget goes into place. And the budget is simply a function of how many lots do we have, how many payers, what are the goods and services that we want or need our association to pay for over the next year, and then we divide it by the number of payers. There may be an inclusion in there for an insurance deductible reserve. Our covenants might provide for a reserve assessment that gets tacked on to the regular budget. Not many covenants provide that. If you're in a condominium development, it's possible that your covenants do. So typically, what we have is a board set amount of dues. It's real common that the covenants will provide for some kind of escalation clause. Now, this is something to watch. It was also vogue to use a CPI clause in older covenants, Consumer Price Index. Unfortunately, the one that everybody used said dues may be increased by that year's CPI. Well, okay, which CPI? Which baseline year? It's an incomplete CPI. It was a good attempt, but didn't quite get us there. It's better to just use a flat percentage, and that's what we do. I use a 20%, which strikes some members as grossly high for board members to raise dues by 20%. Okay, and if you don't like that, then you can reject it. But you're going to have to convince enough of your neighbors to join with you. If we want to go beyond the 20% under my set of covenants, then the members can vote whatever they want in, but they have to vote it in. Same thing with special assessments. The question is, can board adopt special assessments on their own, or do members have to adopt them? Some covenants, boards can do it on their own. Others, I would say the majority of covenants require a vote of the membership to adopt a special assessment. In terms of answering your question, what is the quorum? If the bylaws don't answer it and the association's incorporated, then, and I cite it here, Section 1060 provides it's a third of the membership.
If it's not a threat, Stephen, if you're a corporation.
If you're a corporation and your bylaws don't specify a quorum. For associations, and we could have a good faith debate on this, should it be a third? Should it be a tenth? It really just depends on the neighborhood and whether you can, a third is no good if all you can get is a tenth. So at some point, you have to have a mechanism of getting your quorum. This is a real common question, and I'm not going to answer it tonight. Well, what do you do as an association if you can never get your quorum? There are answers to that. I'm just not going to throw them out there. The best we can do is you use the provisions in your bylaws or in your articles of incorporation that allow you to get to quorum. And sometimes what you'll have is if you call a meeting and you don't have a quorum at the first meeting, then the people that show up can adjourn that meeting and give notice of a second meeting. And sometimes the bylaws will say the quorum requirement is halved for that second meeting. Or sometimes the bylaws will provide whoever shows up at that next meeting, you'll have your quorum. That's good language. And now you have a process where you can get your quorum. What's troubling is if it doesn't have any language like that. If your bylaws simply provide a quorum is a majority of the members in person or by proxy, and that's it. The problem is that we know that there's better language out there, but you're going to have to get a quorum in order to change that language or amend. And we can't get there. Let me talk about minutes for a second. The only thing I'm going to say about minutes is from a trial attorney perspective. When I want to know what happened at a meeting, when the judge or a jury wants to know what happened at a meeting, we could listen to testimony. The problem with live testimony is people don't remember, people have agendas, you're getting different perspectives. It's like the old illustration on perspective in the train where you have person at the front, person at the back, and the person on the side describing the same event, and it's completely different, but they're all looking at the same train. It's kind of the same thing with witness testimony. Under Oklahoma law, minutes are what's called prima facie evidence of what happened at the meeting. And that simply means, unless we have pretty good evidence otherwise, we're just going to take this at face value, prima facie, at face value that this is what happened. All right? So then the question is, all right, what do our minutes look like? If we know this is what is going to be the official record of the meeting, what do they look like? Well, sometimes they look like an extemporaneous speech outline. There's virtually no information. Sometimes they look like a court transcript. Well, Matt said this, and Bob said that was a great idea, but Jane said, no, that's terrible, let's not do that. You know, we don't need all of that. From the association's attorney standpoint, I really don't want that. More words mean more ammunition for the other lawyer. What I want is that there was a quorum, the date, time it was held. I want the notice of the meeting attached to the minutes, that there was an agenda attached to it. I think I said establish a quorum. There was motion second, all in favor, all opposed, whatever. It's just a record of what happened, okay? Again, if you were to go look at City of Edmond, Oklahoma City, virtually any municipality, look at their meeting minutes, their agendas, and their notices. Again, they are subject to the Open Meeting Act, which is much more formal in terms of dates and particularized information, but it'll give you a good idea of how meeting minutes look. All right? Let's talk about proxies. Typically, proxies are how you're going to get your quorum in a community association. A proxy is simply a piece of paper that I execute as a lot owner, as a member, and I give it to someone. The proxy form we use has a blank to write in the name of someone that you want to serve as your proxy, and then in parentheses it says, or if left blank, I designate the chair of the meeting as my proxy. So all I have to do is sign it, send it in, and now I am there by proxy, and I count for quorum purposes. Thing to think about when you send out proxies is, do you want them to be directed proxies, voting proxies, or simply for quorum purposes? And what that means is we can draft them so that I can vote through my proxy. You ever get the corporate, if you own stock, you get the corporate shareholder and it has the boxes for you to check. That's a directed proxy. I want to vote for these individuals. I don't want to give just a blank check. I just want to get my vote in and that's it. It could be a blank check. I don't care what happens. I give my proxy to Jane for whatever business comes before the meeting. I trust her. She's going to vote my interest. That's fine. Or it can be a limited proxy. I give my proxy strictly for quorum purposes. No vote, yes or no. It's just to establish quorum. Unless otherwise, that UOP is unless otherwise provided. Section 1060 provides that the proxy is valid for 3 years. I would encourage you to use longer periods of time for your proxies. I know that there are some proxy forms out there that provide the specific meeting. Problem is, if you don't include language, that specific meeting and all adjournments thereof, well, you've just lost that proxy if you show up and you don't have a quorum. You're going to have to come get my proxy again. So at least make it for adjournments of that meeting, or do it for a year's purpose or a time frame, something along those lines, so you're not having to go get proxies over and over again.
So what if you designate somebody as your proxy and then they end up not coming to the meeting?
You have chosen a poor attorney, in fact. Mm-hmm.
Would it revert?
They have to show up.
The language of your statement, if it would revert to the leader of the meeting?
No, they have to show up.
Okay.
Typically, I sign the proxy, I hand it to you, you show up at the meeting. I guess it's possible I sign the proxy and I send it to the secretary and you don't show up. My proxy is not counted.
Okay.
Yeah. Now, if you're using my form, I don't know if I've thought of that before. So you fill in a name. I guess arguably, if you fill in a name, send it in, and that name doesn't show up, then it would devolve to the chair of the meeting. But I don't see very many proxy forms that have that language.
Okay.
This proxy is formed me in the couple of years I've been with my HOA. Is it really, we have 438 homes. There's 438 pages floating around, and people one by one identified a person to vote for them.
They could.
That's still going on.
Yeah, with that many homes, I would suspect that y'all would make heavy use of proxies in order to get quorum. Not necessarily. I went to an HOA meeting earlier this week. They have 700 and something homes. This is a North Oklahoma City association. We had 20 people show up. This was their annual meeting. And now that I say that out loud, maybe it was reflective of me because they did announce I was going to be there. And out of that 20, we're talking husband and wife couples as well. Yeah, with large neighborhoods, particularly been around for 5, 10 years, high percentage of, I say high percentage, a double-digit percentage of leasing properties, you're going to have a tough time getting quorum, and almost always have to use proxies to get there. I'm going to skip electronic voting. I'll cover this. So when you come across this Class A, Class B language in your covenants, this was a design by someone, I think for a while it was clever, but what you see is the Class B member shall have 4 votes, 5 votes. I've seen 100 votes to 1. I don't do any of that stuff. The Class B member is the declarant. When you're reading through your covenants, if you see Class B member, that's the originator of the development. Whoever signed, whatever entity signed the covenants is typically the Class B member. If we want the Class B member to control everything, we just say it. The Class B member appoints the board. The Class B member unilaterally can amend the covenants. The Class B member controls the design review board. We just set that out in our covenants. It may not be set out like that in your covenants. And if it's not, when it comes time to amend the covenants, it may be that the resident owners can outvote the declarant. Because a lot of times, just the way these are drafted, this form that I'm talking about that does this Class B voting bit. Now this isn't necessarily, doesn't have to look like this. This is just commonly. So if this is our CCRs, we'll have Article 1 definitions, Article 2, it'll be something along the lines of easements or maybe the annexation addition provision. Article 3 will talk about voting, and this is where we'll have the Class A, Class B member. We'll have 4 that'll talk about the ARC, 5 talk about HOA assessments, and then you get all the way down and every contract has legalese, right? And it's always buried at the bottom. Well, part of the legalese, we'll just say Article 10. Part of the legalese for covenants is the amendment clause, and it answers the question, okay, how do we change all of this stuff if we want to? And you're going to want to. It's built into the life of covenants to change them at some point, because if I'm hired by Developers Council, I'm going to have a lot of language in here that you as the consumer are going to read and think, wow, that seems like overreaching, that gives the declarant a lot of power. You're exactly right. That's how we want it. Because at the outset, my client has, we'll say $1 million invested in this dirt, and you have $250,000. Now eventually, the owners combined will have more of an investment than my client, but at the outset, we're going to protect my client's investment. That's why you have all of these developer protections. Well, when my client's out of it, and the association is running, the resident owners are running the association, we don't need all of that language in there. And so it may be time to amend it. It may be that what the developer and I thought were good for the neighborhood, turns out that's not how it worked. And we may want to change the language. So the amendment clause at some point in the life of the association or in the development is going to be a big deal. A lot of developers, when they're drafted like this and say, A members get 1 vote, B members get the 100 votes. A lot of developers think that voting applies to amendments. almost in every case that I've read, it does not. It's this false sense of security, and I didn't think about, well, this talks about corporate voting. Well, this isn't a corporate vote. And usually this block of language says each lot owner shall have a vote, or it shall take a majority or 90% or whatever the percentage is of the members. Doesn't specify Class A, Class B. Well, if it just says a vote of the members, guess how many Class B members there are? One. They get outvoted. So it may be that if you have a recalcitrant developer or declarant, throwing their weight around with the Class A, Class B bit, you can just amend out their rights. Usually, though, if they're throwing that kind of weight around, you really just need to have a conversation and try to persuade them that it's in their best interest to have happy customers so that they can finish out their sales process and get out of the neighborhood. That kind of situation where you have a developer unnecessarily jerking their customers around and customers starting to put signs in their yard and contacting lawyers. It's the old cartoon where the stork has swallowed the frog and the frog has his hands around the stork's throat. Or the scorpion on the back of the turtle swimming across. It's a bad situation. Yes, sir.
So in our covenant, the members can get rid of a board member, but can the HOA get rid of a member?
Yes. Yes, they can. They can buy their house. Yeah. They could buy their house and or they could foreclose on their house and send it to sheriff's sale if they're not paying their assessments. But
there's no law on that, we can't.
Say that again, if they don't pay their assessments. Right?
yeah, we'll talk about collecting assessments, and that's part 2. We cover amendments, assessments, insurance in the next one, but I'll go ahead and give you a teaser. So if you've read on the internet that an association in Oklahoma cannot file a lien against your property, that was false information. If you read further that, well, they can file a lien but they can't foreclose on it, that's also false information. You can lose your home in Oklahoma under properly filed covenants for not paying your community association dues. Now, whether that's actually going to happen is typically an economics question. More likely in a condominium development, probably not so likely in a homeowners association, and it's just because of money. Okay. I'm only going to talk a little bit about enforcement tonight, and this is I guess the precursor to judicial enforcement. So we'll talk about non-judicial enforcement tonight. And this usually comes, well, what good are covenants? I usually get that response when I go through how expensive litigation is. And that's not a reflection on the fact that covenants are unenforceable. Covenants generally are enforceable. It's going to be expensive to enforce them. They do have teeth. In fact, they have, a community association have some of the sharpest, longest teeth for enforcing agreements or responsibilities in civil law. Both monetary penalties and what's called an injunction, and we'll talk about those remedies later. What I want to impress and spend just a little bit of time talking about. Oh, you were hiding it from me. And not to sound too preachy, but the short of the non-judicial remedies, it's the most cost-effective remedy, and it's the one that preserves relationships better than litigation, and that's simply going to your neighbor and having a conversation. Whether it's a business dispute, family dispute, or community association dispute, the lowest level of conflict resolution is having a conversation with that individual. in person, whether it's at their house, over the fence. It's not on Facebook or next door. That is not typically a healthy, productive conversation. It's a great way to get your digs in. It's a great way to show everyone that I have done the right thing. I have been the martyr and suffered with this person for so long. It's not a helpful conversation, okay? Oftentimes, we're on the receiving end of that conversation. If you are, the proper response is to ignore their online rantings or whinings and go to that person and talk to them. It doesn't involve a lawyer. It may involve a little practice in front of a mirror. And I know as adults, that sounds really silly, but it is helpful to have the difficult conversation practice either by yourself in front of a mirror or with another person. Think about what you're going to say. I mean, think about in terms of if you were going to give an appeal on behalf of someone, you wouldn't wake up, throw your clothes on, rush out, and now you're the ambassador. You're going to practice, you're going to think about it, and you're going to consider, this is a big conversation, I'm going to be prepared. It's the same thing. Even if we're talking about, my neighbor's dog is driving me crazy, he's got to stop. That's a difficult conversation. Interestingly enough, I've been on the receiving end of that conversation. It wasn't fun. My dog was driving him crazy. Yes, ma'am.
If you're a board member and you're asked to speak to someone, is it a good idea for two of you to go?
So let's use that question in the barking dog, because that's a real common one. The neighbor's dog is barking, it's driving everyone around it crazy, so somehow now it's the board's job to take care of that. Forget the fact the covenants say nothing about barking dogs. See, the ordinance says a lot about it. And that's usually what you'll see is that owner not talking to their neighbor. They either complain to the board or they call the city action line in Oklahoma City or they call the municipality. The action line is going to be an effective remedy. You've already paid for it. It's going to be cost effective and they'll get the job done. They've tried many dog barking complaints. But the best remedy, if that person comes to the board and says, board, my neighbor's dog's driving me crazy, I want you to do something, the proper board response is to take the person, spin them around, give them some adequate coaching on how to have difficult conversations, and point them in that person's direction. And when they turn back around and say, either you do it, board, or I'm going to sue you, then you have your lawyer explain to them how that's a waste of time and money, and they hopefully will try to encourage that person to go have the right conversation. Boards, I think boards have a much larger job of coaching, counseling, babysitting, we might call it sometimes, just helping people be their better self. That's a really good board function and one that you don't get training for. You're not going to read that on the internet very often. You're not going to get it from a how to be a board member book, but that it needs to be its own chapter. We can avoid so many conflicts. You can avoid so many bills from your attorney by having those. It's not fun. I hate having difficult conversations. I hate being on the receiving end, even worse, of difficult conversations, particularly if I figure out I'm actually wrong. But it is a age-old, tried and true conflict technique. So what if that doesn't work? I did my best, I gave it a good faith attempt to have the difficult conversation, it just didn't work. The next step is to possibly involve the board. Not to send a demand letter, but what I'm looking for is a person that I think has a good chance of reaching this person. I gave it my best shot. I'm looking for not necessarily an intermediary or a mediator, but I'm looking for someone that I think this other person trusts, that this person respects, that they can hear. And I want to take that person with me. If that doesn't work, then we may be moving over to judicial enforcement, the association doing something, if it is a covenant violation. something that is not very well known and definitely not well received from owners when boards tell them this is, and this gets back to our legalese, usually down here, we'll have an enforcement clause. And if you read the enforcement clause in your covenants, it always says the individual owners may enforce these covenants by an action in law or in equity. That just means you can sue them for money or for an injunction. Oftentimes, it will also say the association may enforce, but it always says the owners. That has been true forever, since the invention of covenants. The people, the primary carrier of water for covenant enforcement is the individual lot owner. And so it's entirely appropriate for a board when a person comes and says, my neighbor's building a sunroom and it violates the covenants. It's entirely appropriate for the board to turn that person around and say, great, go get them. Because our lawyer said he's going to charge a $5,000 retainer, and that's not even going to crack the tip of what the litigation is going to cost. And we're looking at our budget as a board, and we've made a business decision. We're going to pay for flowers, not lawyers. That's an entirely appropriate business decision. And that owner has to make the decision, do they want to commit their own resources as opposed to trying to lobby the board to spend the collective resources. Okay? If it's a barking dog issue, then more than likely you're just going to call the action line, have the municipality. I'll tell you, one of the most difficult things, since we're talking about dispute resolution, one of the most difficult issues to deal with is mental illness in the neighborhood. Had a neighborhood where there was a physician, MD, who, I don't remember the specific diagnosis, but the guy was power washing his car from the inside out. And neighbors call the board. It's on his property. He's not doing anything. The board had some resources to speak with his family, and that's usually the best initial approach. But he wasn't violating the covenants. If you want to destroy your car, more power to you. Destroyed the inside of his house, power washed the inside of his house, and it only involved the association. We started power washing the common area, which was just a green belt area, just destroying it. And I would suspect that most states are this way. Oklahoma doesn't have really great mental health support resources. And so I think that's probably the most difficult thing for board members to deal with. So the only reason I bring that up is if you can think about those things ahead of time. I don't think you want to take an entire weekend and workshop this all out, but have a board meeting and an agenda item to discuss, okay, what are we going to do in the instance when we have something like this going on? And having good information, not necessarily knowing a person's entire family tree, but it used to be we knew our neighbors and we would know who to call when we were having a problem, whether it was with their children or someone else. And just the way our neighborhoods are built these days, our porches aren't set up for us to sit out there and wave at each other. So that is another function that board members can really build their community. Now, is that going to show up on a disclosure statement? Are you going to be able to say, well, because we do this in our neighborhood, you can sell your property for $5 more per square foot? Probably not. But I think a lot of those things will come through. I know a lot of people, when they go to buy a house, what they want to see is not just the covenants, not just is there an insurance policy in place, not how much reserve. They look at the Facebook page and they look at the next door. The last thing I want to do after coming home from doing what I do day in, day out is be around fighting neighbors. And I won't buy a house within a neighborhood where everyone's going nuts. And so, as a board, not maintaining peace to the detriment of healthy relationships. I mean, you can have peace just by not fighting, not ignore, or by ignoring issues. That's not what we're talking about. But having some board function or a policy on how to address these issues. You're not going to win every time. You're not going to solve everybody's problem. It's going to be a thankless job and a beating most of the time, but it is a slow chipping away, and it is one of the most worthwhile things I think our boards can do. So that gets us down to informal mediation. Some covenants will provide for mandatory mediation or arbitration. Mediation is simply having a neutral third party, sometimes paid, sometimes not, who is trained to, oftentimes seems like, point out the worst parts of your case and the best parts of the other person's case. That's an old mediator's trick. But what they're trying to do is to get the parties to come to some settlement. And the worn out adage is if both parties walk away from the settlement and are dissatisfied, then that's a good settlement. It doesn't necessarily have to be that way, but there is something to be said about moving from conflict over, the color of a house or some covenant violation that is probably going to get amended out sometime anyway, or if we ask a majority of the neighborhood, we don't want to enforce, but it's there, so we got to do it, kind of disputes. Getting past that conflict and moving on. Arbitration is basically private court system. I am not a fan of arbitration for community association disputes. I want a local judge. I want to stand in front of a local judge, and I want the full court system if we're going to do that. There are other lawyers that they build them into their covenants every single time. I just don't do it. We're going to talk about the rest of enforcement next week. Let's talk about records access. It's almost like clockwork, and you can choreograph how it goes. Individual owner gets a demand letter from the association because he hasn't paid his dues. He disputes the interest or the penalties or whatever, claims he didn't know there was an association. Usually starts about a fight over money. And so when the association says, well, we're going to enforce the covenants and make you pay, now comes the records request. Okay, well, now I suspect that you're stealing all of our money, and I want to know where all of this money is going, and I want to see every scrap of paper in the association. And the board's response is, well, you're just doing that in retaliation. The answer is no. That's the wrong answer. The answer for records request is not no, it's yes, and what records, and let's discuss a procedure for getting you those records. If you go to, again, this is where OSCN is such a good resource. If your association's incorporated, go read section 1065. It's 18, and by the way you do this, if you go to OSCN, so you've got oscn.net. You go there, in the upper left-hand corner, there's going to be, I don't know what you call this, it's the place where you can move your cursor and then text box or something. Yeah, so that'll be in the upper left-hand corner. You do 18 space OS 1065 and then hit return, and that will take you to the statute. Okay? What you're going to read is Oklahoma's law on records requests and access. And what you're going to see is an email fired off to the board at midnight in retaliation of getting a demand letter demanding all the books and records. That's not a records request. Okay? It's not a 1065 request, let me say that. Obviously, it is a records request. When the board gets that, I would suggest that the board makes some kind of response. Because ultimately, even for the person that we don't like, who we know is probably heading us down the road of a bad faith, conversation, and when I say that, I don't mean everyone that disagrees with you is doing it in bad faith. I'm talking about the people that are doing it in retaliation or just trying to run a volunteer board ragged. Interestingly enough, I think that is the smaller percentage. Most of the people that are asking you questions, that are asking for records, are probably doing it out of good faith, okay? But we want to treat them all the same. And the answer is, okay, even though we know now that Section 1065 requires a great amount of formality in records request, meaning a records request, a proper 1065 request is under oath, meaning it's notarized. And it has to specifically identify the records that they're wanting access to. And it's not a demand for produce these record copies to me. It's an inspection and copying right. Now, most of the time what we do is, unless it's just an incredibly overbroad records request, we just copy them and send it to them. We're done. Better yet, we can anticipate this question or this issue that comes up very, very frequently, and we can reply to that midnight email. We can skip the whole, well, your records request is not in the proper form, we'll only address this when we get it. That's kind of board retaliatory stuff too. Not that you can't do that, the law allows you to, but let's skip all of that and just say, hey, why don't you go check out our website or contact our management company, because all of this stuff is already available to you. By the way, did you go to the annual meeting last year? Because we handed out the budget that you're asking for, you know. But having those records online available to them, it cuts down this conversation so much. And honestly, it's a good customer service thing to do. So records requests can be an opportunity for good customer service, and I know this sounds bizarre or ridiculous, but it's also a good recruitment tool. Records requests, collections, enforcement actions, all of those difficult conversations that there's a tendency to avoid, or there's a tendency to just put the screws to someone or stomp a mud hole in them, they're opportunities to recruit board members. And you're thinking, that's the last person I want on the board working with me, but I've seen it. I've seen people treated the way you would want to be treated. I've seen them receive really good customer service, and next thing they want to do is get on the board and serve right alongside with your non-compensated self. Not going to happen in every case, but that's not, I'm not a overly positive person. I've been doing it long enough, I'm fairly skeptical. But I have seen those instances, and it takes a lot of work on board members. It usually takes board members who are willing to be the better person and the larger person, and that's often hard to do. So records requests, they can't beat you over the head with it. The statute not only requires an under oath, meaning a notarized signature, but it has to be for a proper purpose. Well, what is a proper purpose? If my records request says, I think you're stealing my dues, I'm going to mount a campaign to get the board thrown off, give me the shareholder list or the owner list plus a P&L. That is a proper purpose. Doesn't sound like one to me as a board, it sounds kind of threatening, but that is a proper purpose. Okay, virtually everything is a proper purpose under Oklahoma law. If you're a board member, and anyone, manager, board member, is telling you you don't have access to a book and record, that, I don't want to say that's an immediate lawsuit because it sounds like I'm eager to get in court. I'll put it this way. Board members have absolute unfettered access to the books and records of the association. There's no privacy issue. The only time I can think of where we might shield a record from a board member is if we have a board member who, and this is a weird circumstance, if we have a board member whose wife or spouse was the bookkeeper and the board believes that there was some wrongdoing and we're filing a lawsuit and that board member happens to remain on the board, we would exclude that person from attorney-client privilege discussions. But that would be a weird situation. That doesn't happen very often.
What about complaints against board members?
So this is something that y'all can think ahead to, and that's having a complaint procedure and how you're going to handle those.
What I mean is they sent it via email to the president and vice president, but not the whole board. And then the president doesn't show it to the whole board.
Yeah, so that would be a record of the association that potentially is accessible to the other board members. I'll go ahead and tell you this. So the way attorneys work, the way accountants work, when there's an engagement with a corporate entity, we represent the corporate entity. We don't represent the individual board members. And that's kind of confusing because I can't talk to the corporate entity. I have to interact with flesh and blood, the living, breathing hands and feet of the corporation. And I develop really close relationships with board members that have stayed on the board for a long time and associations I've represented for a long time. I've been fortunate to have those. But I don't represent that individual. And so when that individual sends me an email that says, I think the treasurer is stealing from the association, that is a record of the association. Now, given the circumstances, I may not immediately turn around and send that to the treasurer. Hey, this is what the board or the president is thinking. But you need to think in terms, as a board member, that the professionals that you hire, the other board members are entitled to their advice just like you're asking for it. Okay, and that oftentimes that doesn't pose a problem. But when there's board fighting, especially if there's board infighting, more than likely what I'll do is immediately turn around and send those emails, because it doesn't happen very often, thankfully, but what I'll have is this board member's lobbying for a legal opinion that favors their position, this one's lobbying, and I'll just send that out to everybody. Okay.
What record should be online?
I don't know about should. I can't answer that one. I can tell you what I see typically. What I see is a budget, profit and loss statement, typically not a detailed profit and loss statement, maybe a summary. Most associations and their managers are going to use some accounting software like QuickBooks. And these reports are produced very easily. So a P&L summary, maybe a balance sheet. If we have a secure area, I know, meaning that it's members only access, you'll see bank statements, the association's bank statements, reconciliation reports. Man, I get really fired up when I come across an association that has reconciliation or reconciled bank statements. That is an association either that went to our embezzlement seminar last summer or understands one of the best ways to avoid stealing from your association is having someone that does reconciliations and a board that actually looks at them. The no-brainer is covenants. Having all of your governing documents, because that's a real frequent request.
You wouldn't get down to the level of having receipts or...
No, and that's really, if you were to twist my arm and ask me when I start wondering whether somebody has a good faith basis for what they're asking for, when they start asking for receipts, I want to see all of the receipts. Really? I don't want to see all the receipts from my law practice, much less the community association, you know? If I need to look at a receipt, I have an idea that someone, you know, bought too much toilet paper with my credit card and I want to see the Sam's receipt. You know, that's the way it works. So when somebody's asking for all of them, we accommodate them. But usually what we do is that's when we lapse to what the law says, and it's an inspection and copying. We will get all of those receipts, we will put them on a desk, and we'll sit there and watch you. You look through them for as long as you want. Here's your pad of sticky notes. You flag the ones you want copied, and we'll do that for you. But what we're not going to do is unnecessarily monopolize volunteer board members' time. And so the demands that come in, will just copy all of them for me. Nope. That's not what the statute requires. If you're going to tax our time, you're going to do the work. Now, do you have to do that? No. Do some board members do that out of retaliation? Yes. If a person says, look, I don't think we're getting the best deal on our landscaping. I see the landscaping work that's done. I want to see the invoices for landscaping. I would put that in probably good faith category. Okay? Yes, ma'am.
So for instance, someone does request something like receipts, by like providing the management company's information to them, is that like an acceptable
Yes.
way of?
So if you have a management company, it might be written into your management contract how they handle records requests. It may be that the association gets charged by the hour, by the piece, or whatever for handling those records requests. Yeah. But yeah, usually if you have a management company, they're going to be in possession of all of those records. Yes, sir.
Talk a little bit about the need or frequency for legal review of bylaws and covenants. You know,
As often as possible. What are you talking about? No. It really depends. We talked about the life cycle. You know, even after developer transition, you've got all of that language in there about Class B. You can amend it out, or you can just consider it dead letter and it doesn't do anything. It doesn't necessarily require an amendment. Where, I guess the categories of when you should have an amendment, and I've got a great slide. I can't wait to show it. It's one of my favorites for next week. And it illustrates one of the reasons why we would amend covenants. But one of the reasons would be to take out bad language. Well, what's bad language? Language that just doesn't work. It's not functional. A CPI clause that doesn't give us adequate information. It's non-functional. Well, that would be a subject of an amendment. A satellite dish restriction that causes unnecessary confusion. And what I'm talking about is a satellite dish that says there shall be no satellite dishes visible in the neighborhood. It's absolutely unenforceable. And those covenants were probably filed in the 60s, 70s, 80s, maybe early 90s. Or if you're in one of our rural counties and they're still using the same form, they were filed last week. I mean, I still see that. There's a federal regulation that governs satellite dishes. By the way, if y'all are having satellite dish issues, Google this and you will find more information than you can read in one night. Google OTARD, it stands for Over-the-Air Reception Device, where you can do FCC 1.4000, and that will take you to what you're looking for is the FCC's website. It's fantastic. Bunch of good resources, gives you cases that have been tried under this FCC regulation. It's really a wealth of information on this satellite issue. So if we have non-functional covenant language, one of the things that I will recommend eventually, so with our Foursquare there, if we have a phased development, I don't know why developers do this, but some of them do, they'll file a declaration for phase 1, they'll file another declaration for phase 2, they'll decide for phase 3, oh, we've discovered some improvements or maybe some typos in our prior covenants, so we'll fix those and then we'll change the setbacks for this one. Oh, leasing restrictions, that's a good thing, or a sex offender restriction, we'll stick that in here. So by the time we get to 4, we've got a Frankenstein, right? And you're the board that has to administer all of this. That's probably the prime candidate where I'll say, we're going to go in, we're going to do a consolidation and amendment project. Part of this is to fix the problems. Part of it gets back to, you've got a different kind of consumer these days. Consumers that are going to ask for the covenants. And do we want to hand them the Frankenstein, or do we want to hand them something that looks fairly good. So that might be a good reason to do an amendment. Yes, sir.
Just from my working with different groups, you don't necessarily have to be professional in, but every 3 to 5 years, you want to read through everything as a group, as a board. And look and see, is there anything that just sticks out like a sore thumb that you need to have somebody look at?
One of the things I was getting at, early on, the developer protections in the neighborhood specified building materials down to brand name and models. Okay?
Can you get them?
The developer's interest has long since passed, and now they're, but those things remain in the covenants. It would appear to me that just, doesn't seem right.
2 things on that. One, if it's down to brand name, model, it may be that you cannot get those anymore, so that we have non-functional language. Sometimes the idea is, well, why do we need an architectural committee and why do we need these building restrictions when we're done with the build-out phase? And I get that, except for the neighborhoods that were basically wiped off the face of the earth and more a few years ago. And that's just a reality living here. And it was an eye-opener for a lot of folks down there. This covenant language that had sat there dormant for a long time was now a big deal, particularly who is the architectural committee. Because it's real common for the architectural committee language to specify, John, Jane, and Jim as the 3 architectural committee members, and for it to say, when they no longer serve, the architectural committee shall be designated by a majority of the members. Well, that doesn't often happen because developer moves out, we're fully built out. Well, who cares about the architectural committee now? And that may be functional, that may work until we have a catastrophic event, and now, well, can I build whatever I want now?
Yeah. Well, that's kind of what we're getting at. We're in a community close to more, and we're in the business of replacing roofs down there on a regular basis. And the covenants are very specific as to color, manufacturer, what type of ridges, things that were all put in there originally during the development phase.
Yeah, I will say, if we litigate a lot of roofing covenant cases, and if it says weatherwood only, judges, at least in Oklahoma County, have absolutely no problem ordering a tear-off. And I don't care if you've got it fully roofed, 3/4, if the covenants are specific and there's an architectural committee in place. In other words, if the association has all their ducks in a row, I haven't found judges hesitant to do tear-offs. So if it specifies closed valleys, open valleys, metal valleys, painted, whatever, exhaust stacks painted, those are typically all enforceable. And simply because everybody has it now doesn't necessarily mean when a hailstorm comes through, they'll put the same thing on. So in general terms, having that language in place and keeping it in place, I think is a good idea. I wouldn't get rid of it just because it's not an issue right now. There were several neighborhoods. Chimney Hills up in Edmond was the big one. They had several lawsuits trying to enforce a wood shake only shingle, and you're just not going to win that one anymore. Okay, so if you have covenants that say you can only have a wood shake only shingle, and what we want to do is, all right, well, we know we're not going to do that, but we don't know what the alternative is. Well, then amend that language and put what the alternative is. Particularly with roofing, it seems like it changes every 10 years. It used to be the standard you would see 240 pound minimum. Well, that doesn't work anymore. You would see now what we see is a rating, a class rating. For a while there, I saw covenants that was using a warranty period, nothing less than a 30-year warranty. And then some of them, and I have to refresh my memory, but was requiring a 40-year warranty, and you couldn't get a 40-year warranty.
Ours has that language.
Okay. So that might be an instance where you would want to go in and tweak it. Yes, ma'am.
Whose responsibility is it to make it sure a new homeowner has the covenants?
Good question. I kind of take it for granted. So Here is another good thing to know. So that's 16 OS 16, really easy to remember. And when you pull that up, you will see that it's titled constructive notice. And what constructive notice is, it's a legal fiction that says, well, even if you haven't actually read it, we're going to pretend and all act like you have read it. It's the same thing that the officer in the school zone says to me when I get pulled over speeding, and I say, well, I didn't know it was a school zone, and he's, okay, I'm going to give you a ticket anyway. You are charged with notice. And this solves that issue of, well, I didn't get a copy of the covenants, therefore I can do whatever I want with my house, therefore I don't have to pay the association dues. And I hear that one often when we send demand letters or we're in a collections role. And they may have absolutely no idea that they were buying into a neighborhood with a community association. Someone can make that statement and have a good faith belief that they weren't members of an association. I find that incredibly difficult and naive, but it happens. But when that does happen, it doesn't change the rules. It doesn't change their obligation. So one answer to your question is no one has to give them anything. But think in terms of if I'm moving into a neighborhood and what I get from the community association is a packet, a welcome to the neighborhood packet. The first communication I get from the association is a letter that says, we're glad you're our neighbor, we can't wait to meet you, here's what you need to know about our neighborhood. Here's how you get your pool key. Great, I just moved in and it's summertime. Here's the 10 things you need to know about living in a community association with covenants. You're gently instructing and educating them in terms of how they can be a good neighbor. It is a world of difference in that being the first communication, that welcome to the neighborhood, as opposed to I moved in September, first thing I get is an invoice. Welcome to the neighborhood, you owe us $300. Can the association do that? Does the association have a right to do that? Absolutely. Yeah, no doubt about it. But if the most effective collection technique is convincing that person they want to pay on time in the full amount, just like everyone else.
I had heard that realtors provide that information. You let a person know if they're going into a homeowners association or whatever. But
If I'm paying 6%, I would think that they would, but there is no requirement. In fact, if you want to contact your legislator, and we're just about out of time, but I'm happy to answer some more questions. If you want to contact your legislator, go read Title 60, Section 857. And what that says is the seller has to provide a copy of the covenants within 30 days of closing. Well, guess what? I've settled into my dream home. Day 29, you hand me the covenants. That's too late. I've already closed. I'm already subject to it. And the nice, new batting facility I wanted to build for my son in the backyard, now the association's telling me, no, you can't do it. We don't allow that. We can avoid those conversations. The law should require the seller to provide it. Now, it's going to take a fairly, I'm not sure what the appropriate word is. There is ample disclosure on the Oklahoma Residential Disclosure Statement. It talks about is there an association? Does an association exist? What are the assessments amount? Is there a pending special assessment? Is there litigation? I mean, you would have to basically close your eyes and sign the disclosure statement and not read it to not be aware that there's a homeowners association. But this is, again, one of those things. I know there are times in my life when I need a little help, I need a little extra effort from someone else. Not that it's right, it's just what I need. And this is an area where the association or the seller could do that and solve so many problems. I'll tell you this real quickly. One of the things that we do on collections cases, and we're going to talk a lot about collections next week, I want to know as much as I can about that defendant, that debtor, that person that owes the money, because they're going to fall into one of several categories. Someone that doesn't have the money, someone that has the money but for whatever reason doesn't want to pay it because they're angry on this end, or because they just lost a spouse, and who cares about homeowner association dues when you've lost a spouse? I get that. And everything in between. There are people who have moved from either other states, more than likely other countries, who think that your letters and my letters are a scam, that you are just another predator trying to take money from them. If that's where they are, I want to know that. The last thing that person needs is a lawsuit. What they need is a friend and an education. And you don't get either one of those in court. So, having processes in place where we can get them covenants, where we can have these letters, this kind of communication, we're knocking out a lot of stuff that you're going to be paying me for later on. I'm happy to do it. It's what I do for a living. But I'm just telling you that the difficult conversations that we don't want to have, the extending a little extra effort on our side, even though the law doesn't require it, we don't want to do it, we don't have to do it. It does save time, money, effort on the other end. Couple more questions. Yes, sir.
HOA dues, doesn't the title company address that at closing?
It's on a good faith estimate.
If you already have the previous owner, they're going to prorate it.
Yep.
If this is the first owner of that property, are they going to be prorated then to the rest of?
If you use a title company, then and a lender, absolutely, they will be. Yep.
So, can you acquire another residence without using a title company?
Sure. You could deed your house to me right now.
Okay, that answers some questions. Okay.
Yeah. Yes, ma'am.
I'm the treasurer for our association. Every time there's a transfer of title, they send me a notice, I send them a letter, and I attach a PDF of the covenants. If they please share this with the new owner.
Yeah, it's built into the process just because what you're talking about. Title companies, lenders want to make sure there's no taxes, there's no liens, and there's no homeowner association dues. They're going to contact you. So we have this opportunity, who's the buyer, and getting information that we want in their hand. We also know the date of closing, so that if we want to send someone to their house with a welcome, a welcome to the neighborhood package or something like that, although people think it's an assault for you to actually step on their porch and knock on their door or ring their doorbell these days, it's actually not. It's not trespassing until they tell you to beat it.
They don't have to go through the title company because I'm just needed over you, then that negates that whole process.
It does, but that is such a small percentage. And that small percentage is broke down into, I'm transferring property from my individual name to my revocable trust. That's fine, I already own the property. I'm transferring it to a family member, or I'm trying to avoid the association lien and I'm trying to do something tricky. Regardless of the reasons, the fact that it passes outside of a formal closing doesn't do anything to the claim of debt. In fact, the people who think they're tricky and quit claiming the deed to someone else, all they've done is added another pocket for me to pull the dues from, because now that person's liable. The property's liable always. It's either subject to the lien or a lawsuit to collect from the property through foreclosure process. But it's the owner that I can go after personally. And we will go into the ins and outs, talk about foreclosure, talk about bankruptcy next week. So thank you all for being here. We'll see you next week.